Good morning. Can everyone hear me?
Yes.
Sir.
Good morning. Welcome to today's oral argument session of the Fifth District Court of Appeals. I am Judge John McIver. I am joined today by my colleagues, Judge Harvey J. and Judge Jordan Pratt. We have one case on the agenda for today. It is case number 24-1696, MACWCP 3 versus Randy Mask as Sumter County Tax Collector and Sumter County. I would remind everybody that today's session is being recorded and live streamed and ask you to silence any electronic devices that make noise, and also would encourage you perhaps to stay on mute when you are not presenting. The default time for rebuttal is 5 minutes. If appellant would like more time than that, please announce during your introduction so that the marshal can adjust accordingly. Otherwise, 20 minutes per side. Appellant counsel, you are free to begin.
Good day, Your Honors. This is the first matter in Florida in which I've entered my appearance, and is only the fifth time that I have appeared and argued a case since I took a position of compliance officer in a tax collection agency back in 1998. The agency provides services to counties and municipalities in Connecticut, New York, Maryland, New Jersey, and in Connecticut, in fact, we manage a collection of all tax types, and we do all non-judicial collection enforcement, including tax warrant collections and tax deed sales. The four previous times that I had to enter my appearance in Connecticut were when all the litigants and all their attorneys firmly believe that the answers to all the issues relating to real estate ad valorem taxation must be found in the statutes. They believe that the common law plays no part. Well, I prevailed in all four cases, finding the common law to be determinative, and the Connecticut legislature amended the statutes to codify the common law at issue, knowing that the bar and the administrators need the crutch provided by the statutes. The only reason for this appeal and the tribunal court cases below is the fact that the appellees and the Sumter property appraiser failed to recognize that the common law controls whether a parcel within a commercial subdivision is or is not a common area. In 2019, right at the beginning of the quiet tax title case, former counsel for the plaintiff, who also represented a similarly situated tax deed holder, had a conference with Sumter County tax collector, property appraiser, and counsel
Mr.
to point
Malnati,
out
there are a significant number of related interconnected statutory provisions in this case. I might suggest that your time could be well spent trying to clarify for us and streamline for us and simplify for us this case, which is already incredibly complex.
well, then let me just turn.
You might
I was
start with
I was
you might
I was
you might start with what are the issues actually that you are appealing?
This case is actually up on appeal on uh, two issues: failure to cite the appellees as an indispensable party to the quiet title case, and a claim of res judicata collateral estoppel to the findings in the quiet title case, and that finding being correcting the tax deed to show that it is a common area of the Palm Ridge Plaza subdivision. But the analyses of both res judicata and collateral estoppel are fully discussed in appellant's initial brief. But just to sum up, literally none of the four identities that must be present to establish res judicata are present here. And similarly, none of the five elements are present to establish collateral estoppel. But as I write in the initial brief, I encourage this court to use the rule of issue preclusion that's found in the second restatement of judgments. And it reads, when an issue of fact or law is actually litigated and determined by a valid and final judgment, and the determination is essential to the judgment, the determination is conclusive in a subsequent action between the parties, whether on the same or different claim. Now, in the what I call the value classification case, The issue was challenges to classification and to valuation, but classification in particular. The issue in what I refer to as the QT or quiet title case is correcting the tax deed, and in this matter to reference the fact that the parcel is a common area. And what I wanted to explain was that when the subject parcel was created, it's a funnily shaped parcel. It's shaped like a squared off kettlebell that you find in the gym, with the center of the handle being a separate parcel. It's actually a condominium. When this was presented to the property appraiser back in time with the creation of this lot, they used, or they believed, and they told us that statute 193.0235 determined that this kettlebell-shaped property is not a common area. And when it came time to producing the tax deed for this, they intentionally omitted the description or that this property, this funnily shaped property, was a common area, depending on.
Can you address the statement in Appellee's brief that the fact that this was a common area was available in the record and was subject to your client's due diligence, and that it wasn't a matter of them hiding the ball, but simply a failure of your client to exercise due diligence?
That's actually not what's at issue here. What's at issue here is correcting the tax deed. It's tax deed to reflect that. We presented, as I was going to say, it was presented right at the beginning of in 2019, at the beginning of the tax title case. Former counsel spoke with the county and the tax collector. Hey, this is a common area. They refused to address the fact that this is a common area. It's the issue is should have been designated as a common area, and if so, once corrected, it requires, pursuant to 197.443, that the tax deed be refunded. Does that respond to the question?
You say that's not before us. I think you're actually correct. I think there's a lot of things being presented in this case that may not be before us, which is why I had asked you to try and narrow down to the issues that are being presented.
Well, the first issue is whether or not the correcting a tax deed to show that it is a common area is the same. Do they implicate the same issues in facts and law as the value classification case? And I make the point throughout the initial brief that they do not. They're very separate. There's no, the res judicata, collateral estoppel, and even the second restatement rule of issue preclusion simply don't apply here. It's not applicable. And the fact that the claim that the appellees were indispensable parties to the quiet title action is also fully discussed in the initial brief. There's just no basis for there's no basis for a claim that the appellees or even the property appraiser is an indispensable party in the quiet title case. Appellees don't focus on the fact that the statute in which we're acting, that's 197.443, makes it clear how it's to proceed. If it's found that the property description needs correction, it's corrected by court order, and that that then brings about an administrative process by which, if the tax deed holder wishes a refund, supplies form DR 462, and it's a completely administrative process. There's no need for the tax collector or the property appraiser or the county to be a party to the quiet title action.
Counsel, could you clarify something for me?
Sure.
Is it your contention that a statute needs specify all of the indispensable parties for every particular kind of suit? And if so, what room does that leave for the Rule of Civil Procedure 1.230? What effect would that leave for that Rule of Civil Procedure?
The Rule of Civil Procedure is actually is a common law rule. When a statute, and the statute in particular is 194.181, that sets out all the parties who are required in all of those tax and assessment related causes of action. And 197.443 is not mentioned, nor is it mentioned in 197.443. As I said, it involves an administrative procedure. But what is that rule? What is the common law rule on indispensable parties? It really is a rule that says when it is equitable for it is equitably needed for a party to be involved to resolve their rights in an issue. I don't see that they have the public policy and equitable and equity don't lie with the
Mr. Malnati,
county in this case.
I have a note here, and I don't have appended to that note where from the record I got it from, so please help me. In the quiet title case, did your client consent to the intervention?
Yes.
Okay. Please help me why that doesn't close down issue number one.
Well, consented to and it was actually stated in the consent. It was consented to the intervention, but not to establish that they're an indispensable party, but rather to bring them into the case so that plaintiff could get an order to get the tax collector to pay on the application DR 462. It was stated right in the consent, and I believe it was also mentioned in the initial brief.
Yeah.
But there is no statutory and I believe no common law right or issue suggesting that the appellees and even the property appraiser are indispensable parties here. And the only thing that they focus on is a court case, Yorty versus Abreu, which did in fact find the tax collector to be an indispensable party. But even in that case itself, footnote 1 says that the statute on which they rely has been amended, and it may no longer be used to find the tax collector or the county to be an indispensable party under the circumstances presented in this case. Let's just focus on what the appellee focuses on. The appellee believes that the classification challenge statute 194.171 is determinative here. But as I said before, that and the public policy and public interest that's in that case are just not applicable here. This is not the quiet title case, and correcting the tax deed is not a classification case. it doesn't affect classification, doesn't affect valuation, doesn't affect anything. It just says that this is a common area. And with all that goes with that, all the rights and limitations on what the tax deed holder can do. And as we've stated, that this if these had been noted as a common area, especially in the tax deed itself, there are two other parties who would not have paid taxes, would not have paid these taxes. There are two other parties that are affected by this fact, that this is the public interest in the appellee to retain the monies collected on this, I believe, negligently misrepresented as not being a common area. The taxes collected on that, the right to keep it, does not prevail over the public policy that's stated in 197443, which
Just in case you're not on gallery view, I'll let you know you have gone into your rebuttal time.
Then I think I've pretty much stated everything, but except for the fact that when I asked for the oral argument, I stated that I needed to ask questions of the appellees through the court, and the questions are: on what did appellees and subject property appraiser rely to determine that the subject parcel in a commercial subdivision is not a common area? I know the answer to that question, but it's not addressed in their briefs. And where do appellants get the idea that commercial common area is a classification? I believe answers to those, and I've answered them, I believe answers to those are actually determinative of this appeal. I reserve the rest for rebuttal and sum up, and for any further questions the court may have.
Thank you. Mr. Taylor.
Opposing counsel, my name is Cliff Taylor. I represent the appellees, Sumter County Tax Collector, and the Sumter County Property Appraiser. The first issue that was raised was the issue of interpleading or intervention and taking judicial notice. Appellant actually consented to that. What they objected to was the setting aside of the summary judgment. And that's what triggered our focus as far as what's happening, because now, while appellants want to classify their quiet title action as a quiet title action, it really changed when they amended their complaint, especially count 3, when they started a remedy against Sumter County, all of its constitutional offices, by asking for a refund. And while he says that, appellant says this is not a classification case, they focus on the need for this to be declared to be a common area. It really doesn't matter. The statute that's relied on, let me correct one thing in my brief. I had misidentified the statute as 193.023, and I forgot to put the 5 on the end of that. So, but that's what I was talking about. That particular statute is focused really on only residential areas. And there's no question this is a commercial property. It doesn't matter whether it's a common area or not a common area. It's going to be taxed as a commercial parcel. The Florida legislature tasks the property appraiser to assess all property unless there's an exemption, specific exemption, or a special way to treat the property. And they did that in 193.0235. It set out when you have a common area in a residential subdivision, it should be assessed at a nominal value or prorated against all of the property owners in there. But there's a couple of conditions on that. And the caveat is that the developer had to give up all ownership of that. Secondly, the common area had to be exclusive. In the early quiet title case, there's the deed from the developer reserved the right to issue licenses for parking. So the developer never gave up his total ownership of the property. So that's the problem with assessing or applying this particular statute to the case. Secondly, it has to be exclusive to the property owners. And this is a commercial setting where the public can park. So it's not exclusive to the lot owners. So even if you applied that, it just doesn't fit in. But it is commercial. And I think the legislature was clear that they only meant this to be for residential purposes. And getting back to the 60-day requirement of 193, 194, 171. In the other case that was tried, and it was briefed very thoroughly by the tax collector and the tax property appraiser's office. And Judge Nemeth found in paragraph 7 of his order, talking about the Ward case, the Ward court held that whether property owner is claiming that the assessor's action was illegal, unlawful, void, or an improper classification, or for some other reason, the property owner is still bound by the provisions of Florida statute 194.171, which requires a challenge within the first 60 days of that
Mr.
assessment.
Taylor, if you'll just indulge me stealing a little bit of
Yes.
your time. I saw some cases that treat the purchase of tax certificates and tax deeds the same as an assessment, but has there ever been anything that directly dealt with the idea that the voluntary purchase of those certificates is not really the same thing as the compulsory assessment of a tax?
Right, and there is no cases that go in that direction.
Okay.
And that's an important point, that it's a public record about this property, and whoever the buyer is should be aware, especially in a commercial setting, what they're buying. So that's the only thing new really to this case was the treatment of 193.0235. I don't think that had been thoroughly addressed in the other case with Judge Nemeth. But I think it is important because what the appellees would like would be for the court to affirm the lower court, but also to opine into the area of this particular section about common areas for residential that only applies to residential areas, not commercial. So it doesn't really matter whether the designation was common area or not. Anyway, that's, unless you have any other questions, I don't think I have anything else to offer.
Any other questions from the panel? Mr. Malnati, do you choose to rebut? Nope, you're still on mute, sir.
The point is not that plaintiff appellant believed or should have known this was a common area. The point is, and should have known that 1930235 was not applicable. The county believed it. The county, the property appraiser used those statutes, used that statute to determine this was not a common area. We've always been of the business. This is a common area. We asked them, we told them this is a common area. They refused, citing that statute. And all we've done is to move to once it was found in the quiet title case that it was not properly, the property description is not correct, moved to correct, to add the statement that's strict actually from the deed to the property owners association that actually says it's a common area within that subdivision. That's all that has happened. And based on that statute, based on that change, the statute 19743 says that if it is corrected, if a deed is corrected for any reason, the tax deed holder is entitled to a refund if they ask for it. Entitled to a refund. This does not involve classification at all. Classification and nothing that is even remotely within the terms of what Ward said. And they're found, the initial brief actually discusses this. It identifies those other areas, those other issues that are akin to classification and would be subject to the preconditions of 194.171, the classification challenge case. This is not one of them. Commercial common area is not a classification. I believe for that reason, Appellee's argument just falls, and especially their public interest, public policy claim just falls, because that relies on this being a classification challenge. Now, what's the main purpose of rules of res judicata is to avoid the costs and vexation of multiple lawsuits. It's Appellee's and Sumter County Property Appraisers' erroneous interpretation of 193.0235, saying that this is not a common area, that has brought about all the litigation, not only in this appeal, but in the tribunal court cases below. Neither res judicata, collateral estoppel applies here. There's no basis for appellees being an indispensable party. We just ask that the court reverse the order setting aside the judgment correcting the deed, reverse the motion denying the motion to compel the tax collector refund. And by the way, I withdraw the fifth request. It's not appropriate. And the third and fourth requests are merely precatory.
Counsel, thank you. We will stand adjourned.
Thank you.